All right, everyone. Can you all see my screen right now?
Yes.
All right, well, welcome to the Mastering Legacy Workshop. All right, today we're going to be discussing, all things trust, estate, EIN applications, getting into the banking process, and just overall making sure that all the assets that you're working hard to get, they go to your family, not to, challenges court of law or government, if that's not your desire, right? So again, this presentation is for education and informational purpose only. Uh, and what questions you have, free to reach out at elflowellness@gmail.com. Right, moving right along, let's go ahead and jump into this. Right now, when it comes to trust, this is essentially an entity created to hold grantor. Who's the grantor? Say again.
No, I'm sorry. My phone. I'm jumping off the phone now. This is laptop. Sorry.
So it's a trust. This is essentially created by the grantor, individual you, right? Managed by a trustee who can also be for the benefit of certain people or persons. Now, people can be uh, legal heirs at law. Persons can also include definition of a corporation. So, because a person may not have any heirs or children that they themselves may have created, they can still pass assets on to corporation if they so choose for charitable purposes. And this entity is essentially designed to provide protection to the beneficiaries, right? Protection from predators, protection from the public, right? This is just another way of keeping things very discreet. So I want you to look at a trust as essentially your law book, right? Your will and testament, right? Your desires being passed on to the people you want it to happen. Right now, as a beneficiary designation for retirement, investments, insurance, a trust can be used. Right now, when it comes to estate planning and identifying the beneficiaries, sometimes you want people to get things outright, and then sometimes you want to have a plan of action, a backup person. Right, so let's say that you were an individual who acquired some assets. Maybe let's say that you've got a retirement, right? Well, there's such a thing as a joint trust with rights of survivorship. Okay. Now, spouse in this instance would be the person who gets entitled to the stuff immediately, right? But in the event that they have children and those children are not yet of age, then the trust can be listed as a contingent beneficiary, which will essentially serve as the backup in case, both parents were to pass, a child reaches the age of maturity. Now, there are two flavors essentially of trust. There's the revocable trust, which can be changed by the owner, aka the grantor or the creator, right? And then there's the irrevocable, which cannot be changed without the beneficiary's written permission, right? So let's say that a person got married at some point and then they get divorced later on in life. Well, if that person was listed on their trust as a beneficiary and they had to sign for that, then that person would also have to sign that they were being removed. And that may not be the easiest thing to do. But also an irrevocable trust, once it's created, it can't be changed, right? So generally, my rule of thumb is if a person is acquiring assets, acquiring and reaching their wealth and rich number, right? Versus someone who's already in their wealth, already in their rich life, right? Well, then for tax related purposes, a revocable trust may work to the better advantage the person who's acquiring their wealth, and an irrevocable may work better for the tax advantages of a person who has a lot of wealth. Now, if there is not a benefit assigned, then the money goes into an estate, right? So like this is just a person who creates a trust, but they're on their way to growing a family. They're on their way to establishing a business. They don't have anyone that's financially dependent on them, right? Or legally dependent on them. So in the event that there are no beneficiaries listed, right, then what happens? The assets will pass on to the estate. And if there is not one, then the state of your residency will step in and create a custodial list, right? So now the courts get involved, and now that completely destroys the whole intention and reasoning behind creating a trust. We're trying to avoid probate court, trying to avoid the trust being challenged or peeked in and seeing what's held in trust, right? So we have things that trust include, such as powers of attorney, which gives the individual authorized to act for another person in specific or all legal or financial matters, right? It's basically a legal document given to somebody else that says, hey, in the event that this happens, you can do this, right? Now, a power of attorney can be used in multiple instances, not just for financial matters. They can also be used in legal purposes, legal matters, right? Say, for example, if a person was temporarily detained, right? Well, a special power of attorney could be written up, which would allow that individual to make decisions or access certain accounts or perform certain actions. Like, hey, go take my dog for a walk. Here's the password to get into the house, giving you authority and authorization to access the house. Hey, here's where the hidden key is, et cetera, et cetera. It's just another way of just crossing all your I's and dotting all your T's, as the saying goes, right? But when we're doing that, sometimes we're discussing how to do this for children, right? Or for the elderly, right? And so a person that is essentially a competent individual, right, or competent entity is going to go ahead and step in and work on the behalf of the person whose state is managed, right? Now, although I haven't, it doesn't, it needs to be said, right, that an estate is for the management of the deceased or the decedent, right? Now, when we're not talking about someone who's passed, we're talking about someone who is passing or near their end of life, right? So when we discuss custodial trust in the instances for someone who is the caregiver of an older or an aged parent, right? A custodial trust can be created for that type of purpose, right? Whereas also in the instance of a godparent who is, becoming the custodian of a child, the parents who, through some unfortunate event, now have to step in and act as the caregiver, right? So custodial trust can occur in the interest of another person, whether they're dying or because someone else has died, right? It doesn't always have to be related to the individual themselves. Now, last things we'll talk about before we jump into some other things, also still very trust related, right? The document written by a testator, right, which is just like the grantor, the person who is creating this legal document. This will detail what happens to that person's property that was owned by them at the time of their death, right? Who's going to get their stuff, right? Now, if you've seen things in celebrity news or TMZ or, I don't know, 60 Minutes, or, there are a couple of different shows that have talked about certain celebrities who the states have become more notable, and not for good reason, right? Anytime a trust or the estate of a deceased individual or celebrity is talked about, it's never spoken about in good context, right? It's usually due the folly of that individual and the consequences of not having done their due diligence to make sure that who they wanted to get their stuff would get their stuff without any types of hindrances, right? Now, sometimes a person in their haste, because, hey, their health isn't that great and they have an episode that they end up surviving. But during the episode, they said, you know what, I haven't said who's going to get what. Let me just write these things down on a napkin or a piece of paper. I'll sign it. I'm going to date it. This is it, right? But then they survived. They completely forgot about it, but somebody else had a copy of them, right? And they kept it for whatever reason. And then other instances occur like that where the person writes other legal documents in a sense that get witnessed, and rather informally, it still may serve as admissible evidence in a probate court of law if there is no will, right? So reasons to get a will, because you want to make sure that the people you want to get your stuff actually do, right? But because a will can be written up through any random circumstances, a trust differs in the sense that it's the individual, the grantor, the person, you or me, saying, I want this to happen. I performed this document or created this document in the presence of witnesses and a notary public, right? And it also includes a living will, right? To determine who's going to get my stuff. But now I'm saying there's nothing to challenge. Okay. So here's what a default will look like from any particular state, right? It'll have things like, documentation for spouses, right? Appointing the spouse as a guardian for children, right? What the children may have the rights and demands to receive as inheritance, right? Uh, Instances where if a spouse were to remarry, right? And procedures for what might happen if the creator, testator, or their spouse were to die, and what should happen with the children, right? And it can also include other things. This is just, again, just a sample document of what that might look like. But for the most part, this is what a generic will would look like. Now, you can find this at your local courthouse if you're not, you know, unafraid to go down there. I say go down there. It's not bad to become familiar with the legal system, right? The people who are familiar with the legal system, they are active participants in it, right? It may also be a good idea for you to become more familiar with who in your state does what with estate, right? What the estate laws may be pertaining to your state, because there are also differences in regards to the law or the legal processes, right? And the lawful processes that may actually apply to those different states as well. All right. So one of the more common documents that people come across is the healthcare surrogate, also known as the healthcare proxy. Now, this is a kind of I had alluded to this earlier when I discussed powers of attorney. A healthcare surrogate is essentially a medical power of attorney. Okay. It's created for the purposes of allowing the individual who created this document to pass on the rights to make decisions for that person pertaining to life support or life sustaining foods, right? If you're someone who doesn't want, who doesn't want to be resuscitated, it may be a good idea to create that or include that in your healthcare surrogate documents, all right? If you do want to be resuscitated, okay, what kind of foods you are opposed to, like, things that you might be allergic to. It's important to identify what you are allergic to in those documents. Um, what kind of medications you may be allergic to as well. Okay, food and drugs. Got to make sure that you include that. All right. And If you already have a primary care physician, and you want that physician to be the individual to, notate the time of death or anything else like that, or, you want them to become your medical proxy as well, it's also possible, right? Again, I'm giving out suggestions and the different options that are available so that way in these different scenarios where, say, for example, you know, um, we may grow older and have not had any children and may have not had any grandchildren as a result of that. So here we are in our older years and with no one to necessarily care for us, right? Perhaps we're allowing our physician to be the ones to make the medical decisions on our behalf should ever something happen to us, right? So in the events of incapacitation, where a person is, unconscious, in a coma, etc., reasons to have the healthcare surrogate also include making sure that if not the doctor and if not a family member, who don't you want making a medical decision on your behalf, right? So I don't know. Somebody might have an arch nemesis that's been waiting for them anxiously. They're in a coma and they're sitting there with you know, the mischievous hands rubbing together, like, ooh, it's almost my time to become the medical proxy. I already know what I want to do. That's an unlikely situation, right? However, I don't know what superheroes are on this call or watching this recording at some point in the future. So for all the superheroes out there, let not your arch nemesis become your medical proxy. Okay. We've kind of already touched on living will. What should happen if a person were to become terminally ill, right? If they did fall into a coma, again, who is it that you don't want making medical decisions for you? Um, you know, this is good to also be sure to go through for individuals that may have a final expenses related estate planning. Okay, where hey, you create your final expenses, forget about it throughout the year, create your living will. What happens? Your decisions that you made previously aren't the same decisions that you're making now. You're not updating that. Like the living will is also like another way that you update your information. Should you change address? Should you change your name? Right? Uh, should you change it in health status? Okay. So, and the types of treatments that you choose, and all that wrapped up one document. I like to think about trust as another way of looking at the fellowship of the ring, right? It's one ring to rule them all, one document to rule them all. So if you're not already kind of picking up on that, everything that you would get in these various legal documents, you get that or create that in your living revocable trust, or can add that to your living revocable trust, because again, that's amendable. You can update it, you can change it, you can correct it, reasons to be familiar. So for those that are a little bit more hands-on, and you know you're one that is of the woe all ye legal attorneys, and you do your research and you're into doing your estate planning yourself, or just being an active participant in your estate planning, here's a software that I use and I've used for almost the last 10 years. It's called My Attorney Home and Business. Go to go to Office Depot or Office Max or Staples, or any of your office related uh, equipment stores, and they might have this in the software section, right? Not too far away from this software is going to be an actual packet for your living will, living trust, powers of attorneys. There are a whole bunch of different like little packets that you can purchase for like less than the price of $10. The software though, it costs about, I think I paid $75 maybe at one point for this. Prices for this have changed. But I'll tell you this much, not only has it been a benefit to me personally, it opened up gateways to other areas that I didn't know I had skills in. once I did my estate planning about 10 or 11 years ago, I was like, what's the data behind this? Right? Like, and then I came to find out that 70% of people who look like me don't have estate planning. So I instantly changed groups by doing my estate planning. I want you guys to also understand that by you doing your estate planning, you instantly change your status quo. You're no longer in the 70% category of people haven't protected their assets, who best interest, right? Um, and bear in mind that whether you do this yourself, there are other services out there like, Be Paid Legal or Legal Shield, which offer you a service where a team of attorneys do that. So like if anyone is interested in contact number for Legal Shield, I'm happy to set you up with a referral. Clients get a bit of a discount. I don't know if that helps you. You know that the clients that I offered this to, they get to talk to a team of attorneys for 5 different things, 5 times a day if they want. And one of my clients, we actually did their estate planning using the Legal Shield attorneys. They did the estate planning. We took over on the estate planning documents. We put that into the legal trust. Why? Because they wanted the security of knowing and the peace of mind of knowing that the attorney had reviewed their documents, had done everything correctly. All we had to do was just take that, put it onto the trust document. Took us about an hour and a half, going super slow. In case you're not familiar with how the software works, there are tutorials. And in case answers, you can call the attorney hotline. They hook you up with questions regarding the software, a section for answers in case you need explanations and definitions. It's pretty cool. Definitely worth it, right? Again, I don't get anything from that company for promoting that product, okay? It's just a really good product. It also has some other legal documents in there too. I've helped people with traffic tickets, mortgage foreclosures. Okay, that's a little bit of a flex, okay? But I make it easy on myself, okay? Just giving you the inside scoop. All right, now here's the part that a lot of people really want to know. Okay, how do I create the EIN that the bank is going to need in order for me to open up the trust bank account? So what I have here is the instructions for the SS4 form from the IRS's website. Okay, so reasons to get an EIN: started a new business, have or will have employees, including household employees, opened a bank account, changed type of organization, purchased a going business, created a trust, right? Created a personal pension plan as a plan administrator. Is a foreign person needing an EIN to comply with IRS web holding regulations. So reasons why an individual or an entity might need an EIN, I don't know what your reasons are. I do know this. When I'm working with my clients in the past and presently, and they're saying, I want to give myself and my corporation the highest level of asset protection, meaning I want total sovereign privacy protection. I don't want any close to me, any capacity. How do I set this business up to where I'm going to get exactly that? And I tell them the easy explanation is you have a business entity that deals with the public, right? The business is owned by a trust. Trust is controlled by a private individual. We have 2 layers of protection before we get to the private individual. Okay. What your reasons may be, if you need to discuss those, let's do so. But I'm showing you that if you already know what you're doing or what your goals are, you don't need to depend on somebody else. And you're wondering, oh my goodness, I spent $70 on this, and this is definitely worth more than $70. Put your plan into action. Don't wait. All right. Don't hesitate. Work. So what is your estate? At the end of the day, all the money and property owned by a person, your home, your retirement account, insurance policies, boats and recreational vehicles. What else am I saying? And can your estate hold or be posed up? Well, all these parcels of property can be held in possession of a trust, right? And what's the trust for? It's for the purposes of passing the assets on to or legal heirs at law, people you want to get your stuff, okay? And that's it, okay? Now, for those that maybe want to know, how do I create an immediate estate or a trust that's worth hundreds, thousands, millions of dollars, right? This is where we start discussing creation of or the use of insurance policies, right kind of insurance policies. We start talking about retirement products that you might have, right? We may start talking about tax implications that may come along with that, but fear not, we've got people on this call right now to help address all of those types of concerns. So let's go ahead and start. Let's go ahead and open up the floor for the Q&A section. If you've got questions about how to start putting some of the things that we discussed into play, now's your time to either enter those into the chat or feel free to unmute yourself and let's get it.
Just what you said. How do you implement, well, two things. I know there's a big controversy and challenging going on between when you implement, when you try to implement to place a home or land into trust, especially when there's a mortgage. I heard there is a document. I missed the document title. Well, what would that process look like?
Okay, excellent question. And that also gives me an opportunity to kind of start going into software. So go ahead and pull that software up. Firstly, a couple of things when it comes to property. So as long as the property is not pending any type of legal action, right? We don't have to worry about what might be perceived as a fraudulent transfer property, okay? Meaning, person just received a notice from the court, hey, your property is under lis pendens notice. Basically, this is a notice of foreclosure, right? And then all of a sudden you get spooked and you say, you know what, I'm gonna sell the property from myself to a trust. Can't do that. That's illegal, right? You could quit claim it to a third party, right? And that third party might hold that property, you know, either A, for the purposes of paying off the debt, another opportunity for, you know, another entity to pick up the payments, you know, but legal situations, they're all different. So it might be in your interest to speak to an attorney about those specific, right? But let's say that there are no legal matters, right? There are absolutely no legal matters. Screen. First, let's go ahead and create an account using software that we're discussing, okay? Can everyone see the screen?
Yes.
So Now, for this individual, let's say that they are married. So we're gonna say,
Let's see.
we'll keep it simple. Spouse, 7, right? This is part of your user account. Yes. Okay. It's a business name. Basic information. You don't want to create an online account. Why? Because those of us that like our privacy and we don't know where it's going to go, anything else like that, you just want to have immediate access to it only on your device. Mind you, the software, they do have the downloads. There are free downloads that you might be able to find somewhere online, but I don't know about those. I went and purchased the software on a disc. I had to go and actually buy a CD-ROM because laptops don't come with CD-ROMs anymore. Go figure. So I had to attach it, upload the software to the laptop and pump. Right. So that's just another way of me just keeping it offline. Right. If you already have an online account, you're already using something like that, you can also select that option as well. Okay. I'm not going to create a password for this demo because fuck my type of stuff. Create a new user profile. That's not an invitation for hackers either. Definitely, please, no one get the idea of like, you know what? After this, I'm on this guy. Right. Create a new user profile. Nope. I'm gonna save it to the computer, desktop. Right. 7 helps to create a folder. That way, all your stuff is just in one neat, organized place. Right. So, using Docs. Normally, I would start you all off with the. Well, let me go ahead and go through this. Go through the wizard first. So there are two, as you see, this is home and business. There's a business tab, right? And it's got a bunch of different files for 1,000 different documents. So we're going to be doing this for the personal side though. We're going to use the home and we're going to go to estate planning, personal document wizard, right? It'll give you some details about what this wizard is designed to do. Screens that ask specific questions about your life situation based on your answers in the main document list, express documents. So just go ahead and just start this real quick. And then we'll get to the question that's being asked, right? Where to make involved effort throughout my lifetime, or living revocable trust, even the assessment, is telling you whether or not you need a living revocable trust or an irrevocable. You're going to make a single effort, that's irrevocable. You got the money, you know what you want to do, you're not making any changes. It's gonna be that forever. Right? Now, personal document, marital status. We're gonna do this for a married couple. Children, do you or your spouse have any children? Let's go ahead and put yes. Children's name. Hey, I got a sense of humor sometimes. Okay, who are the parents? Both you and your spouse. Is this child a minor? Yes.
Mhm.
Let's go ahead and add another child. Girl. Same thing. Both you and your spouse. Is this child a minor? Yes. Right. And then we're going to continue. All right. And it's going to give you all the suggested documents, right? Administrative worksheet, advanced healthcare directive. It'll give you some more things. Let's go ahead and click on finish. I like to name the wizard. That name, save it. All the highlighted tabs are the things that you're going to need, right? Healthcare directive, revocation of that healthcare directive. Why? Because if something changes, you want to change that, you want to revoke it, revoke the previous one, implement a new one, right? Childcare authorization. Not you, then who? Godparents, right? Childcare instructions for those godparents. Hey, my kids got digestive, a dietary restriction, right? Like we don't, no pork, no beef, no fish, cheese on occasion. Okay. My kid's a gremlin. No food after midnight, All right. No water after 7 p.m. Why? Because unless you want to change bed sheets, hey, all right. So healthcare power of attorney. Who do you want to be in this position? Healthcare power of attorney revocation. Hey, I needed it for a period of time. I don't need it anymore. Revoke it. Okay. Living trust, right? For just an individual. Highlight this real quick. This document is used to create a trust to manage a person's assets during his or her lifetime. It provides payments of income to that person and distributes the remaining assets of the trust upon his or her death. Trust is not appropriate for someone whose estate, including life insurance proceeds, retirement plans, exceeds the federal estate tax applicable of in dollars. So, if you have an estate or a life insurance policy greater than $2 million, you don't need a living trust. And even in the application and in the software, if you read through it, it'll tell you who this is suitable for, who it is not suitable for, right? Reasons to create. Own property to be distributed upon your death. Designate the personal organizations that will receive your assets after your death. Designate the person who will carry out your wishes. A desire to use a living trust and a pour-over will instead of a will, perhaps for privacy reasons. A desire to have a system in place for the management of your assets if you become unable or unwilling to manage them yourself. Or you begin information you may need, name and address of the person trust, name and address of the trustee, who person or organization will carry out the terms of the trust, name and address of the successor trustee, person, organization who serves as trustee after the initial trustee is no longer able to serve, right? So on and so forth. I'm not going to insult anyone's intelligence. Okay. There's lots of things to review, reasons to update, changes in marital status, addition of a child, move to a new state, significant change in financial status. Oh, what happened? You broke 2 million. Awesome. Keep going, right? Death of a beneficiary, desire to add or change beneficiaries, the death of or incapacity of a named trustee. I want to say that, the living trust also gives us milestone mark. Okay, because whether through estate planning, whether through professional development and income derived from your job, right, your 9 to 5 business, right, when you hit that 2 million mark, life starts telling you you have to adjust your mindset even more, right? So estate planning is a great place to start when it comes to acquiring your wealth, planning your wealth, planning the distribution of your wealth, right? Up to $2 million, right? A life insurance policy creates an immediate estate valued up to $2 million or more, depending on income, right? It could be whatever. But even on a life insurance policy or a retirement plan, you can list the trust as a contingent beneficiary, so that way, whatever happens to you or something happens to your spouse, got your plan of action in place, okay? Joint trust. Why? Because you get married, your wife, your husband, your significant other, they've got a trust. Birds of a feather stay together, right? You're both of the same mindset. What happens? Hey, oh, I didn't know you got a trust. You're in that too? Oh yeah, you think what kind of party you think this is? You think I'm what? This is like a prenuptial agreement. I had to make sure. You know, this is a qualifier. Okay. So living trust there, document to hold and manage a couple's assets during their lifetime, right? Still under the federal estate tax applicable, which is in dollars, right? Reasons to update, change in marital status, birth or adoption of a child, move to another state. Same thing, pretty much as before, right? A desire by a married couple to have one joint living trust instead of two separate living trusts. There could be some advantages to having two separate trusts. Why? Because maybe privacy reasons, people may not have gotten to that place in their relationship. Right? But then, maybe someone else is saying, no, I want this to be a surprise and a gift to my significant other. I had this for them set up so that way it was like, oh no, only this was taken care of from out of our joint trust. But hold on, baby. Sugar mama, sugar daddy got you. Okay. It's gonna be all right. It's gonna be okay. It's all okay. Right? As they say in Hebrew, Hakul Beseder. It's all good. It's all good. All right. So living will revocation. Okay, you create a living will, you want to change the living will, you do that, right? Let's go ahead and get to the question. Back to the question. Benaya, would you reiterate the question one more time so that way I make sure I get to the
Reiterate which question, how to create a trust and will, and which one we doing? You got several things you just did.
I think you talked about putting land in trust.
Oh, well, I said, how do you move property into a trust?
Okay. So back to that question of how do we move property to the trust? Right?
And property/land.
Okay. So let's go back over here to the estate planning, right? And trust letter to bank or broker. This letter is used to request a transfer of your bank account, brokerage account, or individual securities to your revocable living trust. To request a bank transfer to your checking or savings account or certificate of deposit to your revocable living trust. To request a stockbroker transfer your brokerage account or individual securities to your local living trust. To request a corporate secretary to transfer your stock in a closely held corporation to your local trust. Land that's being mortgaged or not mortgaged, right?
Not mortgaged right now.
It's not mortgaged. It's free and clear.
Free and clear.
All right, then for the free and clear, what we're going to simply do is quitclaim deed is a legal document in which the property owner, the grantor, transfers all the rights in a piece of property to another person or persons, the grantee. Right? You are passing your rights in a piece of property to a spouse or ex-spouse. You are gifting your property to another person or family member. You are transferring ownership in a property to a trust. We're correcting the spelling of a name in a previous deed. You are changing tenancy, how the property is owned between owners. So let's go ahead and start this document, right? Oh, where is the property that is being granted? I should probably do this the right way. So, for legal purposes, everything is capitalized,
Right.
right?
Oh, does it change into capitalization or you have to do it?
Nope, just simply just press the capital letters or caps lock.
Or better yet, it should have been, how do you fund the trust? It should have been a better question.
Okay, so even this is a form of funding the trust as well. Simply transferring property from one individual to the trust funds the trust just like that. Going to a bank and putting $100 into a trust account, whether that be savings or checking, funds the trust as well. Okay. Transferring property through quitclaim deed also does that. Right.
And the name does not have to go through the state. It's just a EIN number and you just create a name.
Yep.
What gives it the power? The document?
Well, not just the document. I'll also show you what gives you the power to do it, right? Who is granting the property, a single person or a married couple, right? This is usually from the living flesh and blood people. It's the trust. Who is granting the property? Who is the grantor or the original owner? Okay, the single person or a married couple. What is the name of one of the spouses granting the property? That's right, Ms. Who did it?
I know them. Who did it?
Who did it? What is the name of the other spouse granting the property? Mr.
Whatchamacallit? Whatchamacallit?
Mr. Whatchamacallit, right? What is the physical street address? Where will the grantor sign this quitclaim deed? Nebraska, Meade County. Grantors for married couples only. The first spouse is listed here. Said, in case people have questions, remember this section over here, you see quitclaim deed grantor gives you an explanation of the grantor is the owner, all or partial, the property being transferred by the quitclaim deed. Okay. Or information overview, claim deed grantee, topic. Okay. Keep it moving. What is the tax or assessor's parcel number? It'll say something like lot number, town, and a whole bunch of other stuff that gets attached. What is the legal description? The legal description looks very similar. Also include the parcel number. Who is being granted the property? A trust. What is the name of the trust being granted the property? Well, everyone, I want you to pull out your driver's license real quick. I get this question asked very, very frequently. We're coming to the top of the hour, so like clearly we're about to go into overtime. Okay, so some of you guys might be leaving at this point. Some of you guys might be staying at this point. I told you it was going to be a 1 hour intensive. Did I give you a 1 hour intensive?
Sure.
Right. So here comes the name of the trust, right? When you look at your driver's license, how is it spelled?
In capital letters.
All caps letters, right?
Yep.
Is it first name first or last name first?
Last name first.
Middle initial, right?
No, for me, they spelled out my whole name.
Yeah.
The whole middle name,
Yep.
middle name. And then here's the rest of it. You ready? Everybody ready? Everybody see that last part?
LR.
What is it?
LRT.
Revocable trust.
LRT. That's it. Living Revocable Trust. LRT. Living Revocable Trust. What is the name of the trustee who can sign on behalf of the trust being granted the property? In English, how do you properly spell your name?
Correctly.
Say again.
I said I spell it correctly, no slangs.
Okay. So how would you spell the name that is on the driver's license in proper English?
Fir-
Your full name.
First name,
Capitalization first, then
middle,
lowercase.
Capitals.
Uppercase, lowercase.
Uh-huh. Got it. That's the signature.
And then AR. But I want you to get more familiar with this one. Everybody see what that says?
Yep.
What does that say?
IT. What is
TT.
it? What is it?
Right? TTEE, trustee.
Trustee.
TTEE. That's going to be how the trustee signs their name on a document every time. Anything that's related to the trust, anything that's related to the trust bank accounts, anything that's related to the trust property. Okay, that's how it's going to be signed. Who is the name of the property to be transferred or titled to or deeded to? Capital letters, last name first, first name last, middle name, LRT on all property. Who's the deed going to? Last name first, first name last, middle name, LRT, all capitals. Who signs for it? Uppercase, lowercase, TTEE. Whenever you see an authorization and a signature, it's uppercase, lowercase. That's the living person. It's not the trust. The trust can't sign for itself.
Yep.
Everyone got that? The trust cannot sign for itself. Okay. What is the physical street address? Is money being given in exchange for the transfer of this property? Yes. Why? Because depending on the state that you're in, the gift taxes might make it more expensive than you were initially going to go ahead and pay, right? But what do you have in your pocket? It might be worth it to simply sell it for $2 or $200. That's simple. Keep moving. Does the grantor wish to reserve any interest in the property's oil, gas, or other mineral rights? Certainly could, or you could not. Why? Because when we're talking about land, it's not just what's on the land, it's what's in the land and above the land, right? So, yes. LAW, land, air, water. Okay, land, air, water. People want to buy it. They want land. People want to buy it. They want to buy airspace or space, right? That's why they put satellites up there. It's another form of real estate. Okay, water. People want to buy water, bodies of water. Why? You can build an island now. People are building islands out in the middle of the coast, off the coast of other land masses. They're building islands, right? Someone said, "Oh, God stopped making it. Man knows how to make it." Doesn't mean it's the best one. It's not built on a stable foundation. It really is. It's not built on a lot of stable foundation.
Please tell that to the people on Tybee Island.
You know what I'm saying? All right. What percentage of mineral rights does the grantor wish to receive? Let's say 20. Right? Because there's a 20% rule. Benaya, you want to talk on that real quick? Let's get some tax saving strategies also into this. Chime in whenever you like, whenever you're ready.
Continue.
Continue. Okay, so we got 20%. All right. Actually, let me go back real quick. This is percentage reserving mineral rights. If you currently own an interest in mineral rights on a property being transferred, you may wish to reserve this interest. Unless stated otherwise, the transfer of mineral rights with the property may be assumed. That's acquiescence. That's you agreeing by being silent. Okay, a mineral reservation clause should be considered if you believe you may own an interest in oil, gas, or other mineral rights that you do not desire to transfer as a part of this deed. So you can do 20%, you can do 100%, whatever.
So,
Yes.
no, go ahead. Someone was going to ask something else?
I thought I heard you say so.
Yeah, I thought someone was going to say something. So if you do 20%, the other 80%, how is that accounted for?
The other 80% goes into the trust. It's owned by the trust.
It's assumed that it goes to the trust. Now, if you retain, remember, if you don't say it, it's assumed that the rights get passed over. Let me go back real quick. Unless stated otherwise, the transfer of mineral rights with the property may be assumed. A mineral reservation clause should be considered if you believe you may own an interest in oil, gas, or other mineral rights that you do not desire to transfer as a part of this. So if we transfer 100%, we retain 100%, that means nobody else gets it. But then after we die, who gets it?
Right. And then also this tax liability, because you'd be also liable for 100% instead of 20%. So the purpose of putting things in the trust is to protect yourself and also be anonymous to what's going on outside.
Yep.
So if a person dies and hypothetically there's nobody else coming after them.
It would if you had 100%, it will go to an estate. It won't be in your trust. If you had 20%, only 20% liability you will have, and then 80% will still be in the trust.
Yep. And so that 80% rights would pass on to the beneficiaries cetera, right? And they would have only lost 20%, which went to the state.
Ah, okay.
Is the grantor desire to reserve life estate interest in the property transferred? Talking about land? Yes. Okay. This is a clause which should be included if the grantor wishes to grant property to a child or other person upon their death. Hey,
And we know that
my
as
bad.
that, like
There you
insurance
go.
policy.
Exactly. It's yours when I die. You know, this is probably one of the few times where like over my dead body comes appropriate.
Literally, right. And you do not want to transfer it to a child.
No, you don't. At least not directly. You know, there is a lower tax bracket, absolutely, but a child doesn't know how to manage it. So you got to put it into a custodial trust. Okay? Like we discussed earlier. I hope everyone's like putting pieces together and like, you know, pictures starting to become more vivid. Is this helpful? I just want to know, is this helpful for anyone?
Yeah.
Let me also check the chat real quick. I know we had one question.
It's like, are you picking up what he's throwing down?
Mm-hmm.
That's right. Software at Office Depot, $39.99. My attorney home and business. That's right, $39.99. Thank you, Mr. Mama T.
Mm-hmm.
And the illest corporation in Nebraska, son. That's right.
Uh-huh.
You got to be careful though, because you know people with bananas out there, they don't like certain.
Okay, clear.
That's a belly reference for those who don't might have gone over some.
Yeah.
Yeah, it went over mine.
SIE. I'm talking about those SIE questions. I say that.
There's also that too.
Right.
You know who's from Nebraska?
Who?
One of the founding members of Berkshire Hathaway,
Really?
Warren Buffett.
Stop.
I always get curious about like small towns and like how well certain business models might work in those small towns. Like
Mhm.
estate planning is a relationship business. It's not a transactional business, right? And in small towns, think about that. Wealth is being transferred directly from individual to individual. It's you know, something to think about. All right. If you're ever curious about how wealth works, study wealthy people, right? Does the grantor desire to reserve a life estate? Yes. Right. Who's preparing this quitclaim deed? Prepare his name. Fill the blank with your full name. Go. Congratulations, done. Go ahead and save. Demo. Summary. Now let's look at this real quick because although we didn't talk about it, it's listed here. What do you see here?
You need a notary public.
Need a notary public. What does this tell you? This tells you that in order to put your legal documents in force, into power, you only need to know what you're doing, put it on a piece of paper, and then go get it notarized. That's it, right? This type of document also a little checklist. This is for you. This isn't for the people that you're taking this to, the banks or anything else like that. Quitclaim deed needs to be signed by this person or persons granting the rights to the property, grantor if not a trust, so on and so forth. Right, the document should be signed in the presence of a notary public so that the agreement can be recorded in the public records. It becomes public record. Right, each page of your deed needs a minimum of 1 inch margin on all sides. Do not allow signatures or the notary stamp to run into these margins. Right, meaning if you can't meet the way that they specify these documents are created, you're invalidating your own document. Okay, that would suck For someone to be like, oh yeah, yeah, your father passed this on to you, but unfortunately, in a state like California, where Kamala Harris was the prosecutor for the state, or in a state like Nina Simone, who then said that her daughter was improperly using trust, then goes and revokes authorization to the daughter and grants it to the state to then go and make a likeness film using an actress that looked nothing like Nina Simone. Big shout out to Rashawn for sending me that video.
Mm-hmm.
Big Rashawn.
She used to
All the
live in
drink.
Hyperion.
Yes, she did.
Mm-hmm.
All right. What else does it say? After being signed and notarized, the quitclaim deed must be filed in the city or county where the property is located. That's all you got to do. After a small fee must be paid at the time the quitclaim deed is filed. All previously billed county taxes must be paid in full prior to the recording date. Hey, you got to play this game to pay it. You got to pay this game to play it. Okay. But this, what else is the legacy built on if not built on what you created, right? You have to give something to create something of value. All right. Even if you cut the grass on this property, right? And you do that for years, never do anything else with it. But that quitclaim deed has been transferred into a property. And attached to that property is also a lien that's held by the trust for all the work that the owner of the property, the control of the property did on cutting grass, maintaining mineral, oil, water, etc. reserves. Y'all better calculate some value. Calculate some value and make it and continue to let it grow. Because the real land that God's no longer making, every year it grows in value, regardless of how real estate property interest rates, property value might go. It doesn't. The value of land does not change. Anyone who has children, the reason why people buy land, I'm learning this, sharing it with you guys. The reason why people buy land is because it's the #1 asset pass on to their child. It's the #1 asset to pass on to a child, not a house.
Right.
I said land, not a house. Land is the #1 thing that people want to pass on, right? Build on it and still rent the property that's on top of the land. I own the land. I want to be landlord. I want to be a landlord. We want to be landlords.
Right, that opened up another door.
Open up another door. So
I do
we
know
did
that
the quitclaim deed.
Good. Sorry.
No, please continue.
No. Good. You summarize.
No. I'm not summarizing. We're still going. We're in overtime. So until people have no questions and I got nothing left to talk about.
You have nothing left to talk about? We don't got that much time.
I said it was an intensive. I said it was an intensive.
Wow. Wait, where is it
All
going?
right, so question, because you said to pay the fees and everything. So when you pay the fees, it's based on the date that you paid. So later on, when it becomes effective, there are no additional fees to pay. Yes?
Correct.
Or am I
it's
not
open.
understanding?
No, you're right.
Solid, but then there's also fees on the property.
Right.
So the fees to file is one-shot deal. The property is consistently the taxes. And if I heard correctly, and anything else that you contribute to that, cutting the grass, watering the grass, maintaining the minerals, rights, and supplements on it, and anything else you do will be added into that to recruit incur value.
Right. Let me go over here to the trust real quick, right? Because there's like, I've said this on some of our calls before, but it doesn't really hit for some people sometimes, right? Reasons to create a trust. Own property to be distributed upon your death, right? You desire to have a system in place for the management of your assets if you become unable or unwilling to manage them, right? Now, I want everyone to understand something. You can use a trust like an unincorporated business association. What we're talking about is also how to create a business that you don't register with the state and you still play the game the way that it's supposed to be played, right? Still play the game the way that it's supposed to be played. Don't have to register with the public Secretary of State. Don't have to do that. Create your trust in your bank account. No one is telling you that you can't do these things. Everybody with me so far? Right? And then through your trust, you continue to move quietly and discreetly on any database. Oh, who owns this property? We're not at liberty to say. We don't put this type of information in the public. Why? Oh, because when it comes to land, it's Truth in Lending Act. For those that are buying homes or buying property, right? Get a loan, you got Truth in Lending. The contract only allows for 2 consensual parties, no third parties allowed.
Right.
On a retirement product, it's 2 consensual parties, the employer and the employee. It's no one else's business, right? On a parcel or a deed for property, it's the grantor and the grantee. It's 2 consensual parties, no third parties allowed. So here it is that you're creating your own third party, your own entity, right? It looks like your name on your driver's license. It sounds like your name on your driver's license. But for legal purposes, it's a completely different entity. Oh, isn't this your name? Well, it resembles my name. Oh, well, we're coming to you for this notice. Well, that's not for me. You're addressing it to the entity that I may be associated with, but it's not for me directly. This might sound like a mind game,
It is.
as Mama T used to call it back in the day. Don't play mind games with me. Don't you play mind games with me. I'm not playing mind games with you. For legal purposes, you have to be a literal person. Literally. You have to be not, oh, well, the interpretation of this means, so, no. You, on that contract that you're creating, it is a literal agreement spelled out in black and white what it is that your wishes are, how the trust can be used, how it cannot be, and it's been notarized and then recorded into the public. You want to know, you got to go talk to those people. If you don't know, you shouldn't be talking to me. So here's some other things, and then let me stop sharing the screen. Some other things that I want you guys to consider, right? The name of a corporation, can it be copywritten or trademarked?
Yes.
Yes.
Oh. What do you need in order to use a copywritten or trademark name?
Mission.
Mission.
Oh.
What?
I think we just created a contract in perpetuity. that protects the name of the trust
Mhm.
if you wanted to.
Huh.
Right?
Huh.
Right? Some of you guys might be having children. Some of us might have children. You want to teach your child in the way that they should grow so that when they are old, they will not part from,
Right.
right? They will stay on that straight path, right? Okay, hey, I'm giving you something that's going to protect you. From the crown of your head to the sole of your feet. Here's a copyright. Here's a trademark for a name of a trust that I created in your interest with an EIN number. I started using that as an unincorporated business association of acquired property I purchased using your trust as the vehicle's entity and name. You reach the age of majority, or if something should ever happen to me, you shall have this. And should anyone ever seek to attempt to destroy what I have created for you, because of the copyright and trademark provisions, it will not be able to use your name without your express.
And it
We
won't
gotta
be
also,
into the public domain.
no.
So what about your
It's
intellectual? Because that's
same,
your likeness and your,
same thing.
yeah.
You know, here's something, because we're talking about the beginning of life all the way to what most people will consider the end of life, failing to realize that your unincorporated association never really dies. Business can continue on forever. Legitimate can, unless the society that recognizes that entity pays and crumbles, your business can last forever. Right? At
Yes.
the time of a person's birth, what's one of the first images that most people get for their children?
Their feet,
And
their head, or their feet.
but does the footprint or fingerprint ever change?
No.
No.
Now, it is the one constant forever.
Yeah, it's a legal document. I went to a nice little fight over that. They said, where's the birth certificate? I said, here's the certificate of birth, fingerprint and footprint. No, we want a birth certificate. No, here it is. This is the certificate of birth. The footprint and the fingerprint of my child is here. That's it. I didn't create the other one yet. I don't want to create it. It took me a couple of years until finally I broke down, but he was a free man for 5 years, 4 years, because he didn't have that birth certificate.
See, now for anyone who's a parent, has children, and they're like, well, I want to be able to be in control of my child. I don't want them to become a product of the state or anything else like that. Well, get your own footprints and handprints done and then go notarize the document that you and another person witnessed together that you created a child on a certain day and a certain time, weighed a certain weight, had certain hair color. I mean, you want to create it first, create it first. Now you know how to create it first. And that intellectual property that you created first now serves as intellectual property, stuff that you use for yourself. Hey, here's our copy of the certificate of live birth. Here's yours. Put the time on it.
There you go.
It goes into the public.
Back to
There you
funding.
go.
So how
There
do
you-
you fund the intellectual, how do you place the intellectual property business into the trust?
Just like before, transfer it.
Transfer it by state and by, whatever the intellectual, well, say the intellectual property, there's a transfer for intellectual property on that too? Or you have to
Yeah.
create, okay, cool, got it.
So let's say a book. Let's use the example of a book, right? Miss Tracy, Rashawn, you guys can help me out. I'm not a specialist in this area, so you're gonna help me and help everybody else at the same time. So we get to try this out. real time, okay? Ms. Tracy, can you transfer an ISBN number?
No.
What can you do with it though?
Well, you can use it because that's, you can use it to buy and sell, but you want to make sure that you own those ISBN numbers and not, for example, Amazon or a company that is printing your book, because once they have that ISBN number, you don't own it.
Don't own it.
Okay,
It's
so go
not-
back to the original question again, because I heard something. I want to make sure that was it. So the
Now
original
you heard
question-
it. You
Right,
heard it.
right.
You
And I heard
it.
what you said. I'm like, oh no, let's go back to the original question and listen to your answer. So the original question about the ISBN number, can you transfer it? And you said no.
Yes, I can transfer my ISBN numbers to my children. Yes, I can.
Okay. And
Yeah,
you can transfer it into your trust, and then it'll be secured and protected there because
correct.
it's yours.
That's the
Correct.
only way to transfer those. That it's like a license number on your intellectual property. It can be scanned by any international entity, so you
Mhm.
can buy and sell,
Mhm.
but nobody else can use that number.
Who
Correct.
can buy and
It's
sell
not-
now? So now here, what's the purpose of the trust? Is two things.
Mhm.
One, to say, oh, see, do we need to drop that nugget in there, or we just pull back? We going in?
We
Go
don't throw
ahead.
it. Come
Go
on,
ahead.
this is intensive. This is
All right.
intensive. Come on now.
So what's happening now? One, we're protecting ourselves, and two, who else we're protecting ourselves from? That three-letter people. All
Mhm.
right, and it's not ABC.
Right, right.
And so
Okay.
when that drops in, then now you're off the grid.
Mhm.
You make $1 million and be on Medicaid. Why? Because it's in your trust.
Mhm.
And you got control, the trust has control of it because it was in a corporation name,
That's good.
capital.
That's good to know. Yeah. And you also have to make sure that every format of your intellectual property has its own ISBN number. I
Yes.
don't care if your book, your ebook, your Audible, your hard copy, those are 4 formats of the same intellectual property, but each one must have
Mm,
its own individual ISBN number.
okay. Again, I hear another concept. Oh, sorry, plug. Okay, I hear something else coming up that we're gonna do a mastermind on. Got 2 people on how to create and distribute licensing and books.
Intellectual property.
Mhm.
Now, here's something else that came up the other day, right? I posted into my stories. I'm not sure if anyone's familiar with John Hope Bryant, right? Well-known name in finance amongst BIPOC communities, right? And he did a little bit of a post or a story highlighting an NBA player, right? Caleb, in particular. I'll share it with you guys later on. Okay. Now, this young man asked, no, it's not the NBA, the NFL,
Oh, yeah.
if they could pay his LLC. And the NFL was like, why? He was like, so I could get the tax write-off. Right? And the NFL was like, no, because we're getting the tax write-offs.
Exactly.
Okay.
In actuality, you say, if you pay me as a W-9 employee, I will save you X amount of dollars. Why? Because they don't have to pay the Social Security or matching funds. So it's how
Right.
you word it with the corporations. So I'll save you some money by paying me off, not off the books, but paying me direct. And I'll take care of everything else.
The 99 W-9 employee, versus W-4, W-2.
That's it. Who gets paid first? 1099, you get paid first. W-2, everybody else get paid first. You get the leftovers.
Here's also the thing about this too, right, guys? Because see, they just got to put money into an account. They don't say which account it got to go to, right? So now here it is that he could have just been quietly just saying, hey,
They put in
here's
his
the
name.
account number that you pay,
Right,
right?
right. There you go.
He could have just totally just had his own trust, because a trust is still created for the benefit of someone else or the living person. So it's still legally on board, right? It goes to the trust account. From the trust account, bing, bang, boom. What do you got to do? Right? That's all. Make sure you keep your proper accounting.
So,
And then,
so,
go ahead.
so with that being said, it was the way he presented in that manner, and because 10 times out of 10, the legal representation is still in bed with the NFL, so they wouldn't give him a one-up to financially secure his family and exclude, which would be a minuscule amount of money that the NFL would lose by him being paid directly as a 1099 employee as opposed to
Right.
a W-9.
Right. They'll
Right.
lose it, they'll lose and they'll gain. It's like, no, but it's really coming down to, no, you can't come into our club.
Right.
And here's the funny thing too, right? Like, instead of just them just paying him outright and saying, like, you know what, like, we're gonna leave all the expenses for you to deal with. We're gonna let you deal with the IRS, and we're just gonna give you all the money for taxes. You don't have to manage your retirement account or anything else like that. Here's the thing, right? The vast majority of athletic entertainers or athletes or celebrities of all sorts is that just because they've got talent doesn't mean they've got management skills on maintaining their money. So because of that, there has to be a system of checks and balances that's in place that takes care of the entire league, right? The entire association. So Caleb is one example of rare exception. He's not standard. Everybody get that? Because, like, if other athletes came and started saying, yo, like, pay me the way that you're paying Caleb, you're gonna be like, yo, you're gonna put us in a bad position, and they're gonna start saying that our fault, these athletes are bankrupt at a faster rate. We manage their money, but they still go and blow it. The NFL, the NBA, they're at least helping the athletes out by making sure, like, hey, we're gonna pay you every couple of weeks. You know, like, because if you gave somebody, how much was the contract? This guy just recently got $300 million contract.
Mm.
I forget exactly. I should know his name.
Jaylen Brown got 325, but then somebody else, somebody, I think it is his teammate Jason Tatum just received like 4 something. So it's like, we talking about almost $500 million, and not to get too far off what we talking about, but Jaylen has set up a financial literacy and ways to help that money generate more wealth in his spectrum of things he's doing in that city, in that town, and throughout the country. That's something that I do know about him.
Can you imagine him doing that into a 1099? And he can now fight, man. He'll never, IRS will get a check for $1. What? I got all these expenses here that I'm taking care of, and donations and charities and events. But you made 400 million, but I only got left this right here.
I was only able to keep 50,000.
Right.
That's it.
That's it.
And in the 50,000 I kept, I paid expenses, my own personal expenses with the 50,000.
That's it. All you have to do is prove to the IRS that it's for your corporation, or I'm gonna say it, I'm gonna let it go, foundation, corporation. All right. That word that's snuck in there, and people looking at that word too now. So this is not profit, but then you have your foundation. which you keep control of the assets you drop in. Oh, let me stop right there.
Come on.
So
So I know we still got some more questions, you know, there's still some more questions for this Q&A session. You know, we said it's an intensive, you know, we still got some battery power left. Come on.
So if you having the trust and you have your accounts, your personal accounts, do you go ahead and take whatever business accounts that you have and put it up under that? And that's just a formality of going to your bank and telling them, hey, my bank account that I have for my business, I want to also put this under that umbrella.
So let's talk about the 400. Is it $400, Benai, or is it 600?
I don't recall. Don't recall.
Say again? Don't recall?
don't
Okay.
recall.
There used to be a $400 annual rule by the IRS that anything that you generated in additional income over $400, you had to report.
It's the 600.
600 now?
Yeah. I had to figure out what you were saying. Yeah, $600. I got in trouble for that. I paid people more than $600, and they said,
Gotta
"Where's
report
your
it.
W-9? Where's your W-9 at?" Well, did you report your W-9 to the person you paid? So long you stay under $599, you're good. Independent contractor, whatever it is, anything over $600, you got to report it to IRS, or you can't take the write-off.
Yep. So anything that a person would make over $600 has to be reported, right? Now, you have professional business, you also have personal business. And a lot of us have personal business. We don't know that we have other business that we're generating income from. So simply take a portion of what you're generating and pay yourself out for those activities. Then pass the tax on. That's all. Just keep passing it on. Just keep passing it on, passing it on, passing it on. Right? There's also there are hundreds of ways to reduce your taxable liability.
So many.
Really, really, there are hundreds of ways to do it. You know, Benaya and myself, we've helped people lower their taxable debt.
That's
Oh.
it. I'm
So-
we're working on one part, and I have a client coming because I just gave her some quick advice and said, hey, make sure you take this, and this with you. Take your light bill, your gas bill, whatever you did to donations, and bring it to your accountant, let him add it in. He said, he never asked me for that. I'm like, well, then you need to upgrade, my dear. That's why I'm talking to you. And I'm talking to her to check her insurance policies while I'm speaking to her, giving her the gems to check her financial policies. And what we're in the business of, financial literacy. So
Right.
that's what we're here for. The team L
Yes.
Weldon. And then if we got problems with everything else, we got people we can make a phone call. Give me a minute. Let me make her.
Know somebody. Know a
Right.
guy. Know a girl.
Right. No, God.
Right. So, you know, there are a lot of possibilities as far as what can be done and how and what this also does, right? So I guess we're at the point where since there are no other questions and, you know, unless someone does, if you have questions, feel free to put it into the chat. Chat's still open, right? But I want to close out, I guess, or start to close out by saying this. Part of the mission, focus of what we're doing here is to change the narrative of wealth and how it's managed or controlled by people within the BIPOC community, right? Black, indigenous, people of culture, right? But going back to like I mentioned at the beginning of this call, 70% of people who look like us, all of us, right, on this call right now, die or are living right now without any form of estate. right? And we're talking about millions of people all within the country with hundreds, thousands, millions, and billions of dollars in financial services or financial products that they have not identified or updated beneficiaries, custodians, next of kin. They haven't done any of this stuff. And when any of us pass, question again that I raise is, who do you want to have your stuff? Who do you want in possession of the things you worked so hard for all your years? Who do you want in possession of them? Right? So guys and gals, if you've got any more questions, if you would like to maybe schedule a one-on-one, or you're interested in turning this new found information and knowledge into a viable business, definitely feel free to reach out to any of us that may have invited you. Contact us at ELFLO Wellness, LFlow Wellness, gmail.com. If you'd like to email us any of your questions and your concerns, any of your thoughts, for those of you on YouTube, don't forget to like, share, subscribe, leave a comment down below, and check out the link that's also somewhere down below. Get in contact with us, connect with us on social media, Facebook, Instagram, Twitter, LinkedIn, all over the place. We're here, right? Appreciate everyone's time and presence, most importantly. Ladies and gentlemen, have a great one, right? Mastering your legacy.
Well, peace, y'all.
Peace.